morning. Welcome to the Regulation Subcommittee meeting of the California Paraprofessional Program Working Group. I'd like to just take roll. Hartston.
Here.
Sarouche.
Here. Good morning.
Good morning. Well, we're ready to go. We have a number of guests, so I'll let Leah go ahead and take over.
Okay, I was just saying, have one attendee. Does anyone want to make a comment? So raise your hand. All right. So great. We have a packed agenda, and I'd like to start off quickly by just doing introductions, and then we will kick things off with Professor Sklar. So everybody here knows me. Linda, want to introduce yourself real quick?
Sure. I'm Linda Katz. I'm a principal analyst with the State Bar, and I'm staff to this working group.
All right. Fariba.
Good morning. My name is Fariba Sarouche. I am the supervising attorney for Self-Help Center and Family Law Facilitators Office here in Santa Clara County.
Jason.
Hi, Jason Solomon. I'm executive director at Stanford Center on the Legal Profession. Good to be here.
Great. Tara.
Good morning, Tara Sklar, professor of health law, director of health law and policy at Arizona Law, and a consultant with the California State Bar.
Greg.
Good morning, everyone. I'm Greg Fortescue. I'm a lead attorney for the California Supreme Court, and I'm a liaison to the working group.
Tom.
Tom Gordon, Executive Director of Consumers for a Responsive Legal System, also known as Responsive Law.
Brady.
Hi, my name is Brady. I'm an Assistant General Counsel in the Office of General Counsel at the State Bar, and I am staffed to this working group.
All right. Last but not least, Amos.
Good morning, Amos Hartston. I'm a Deputy Attorney General with the California Department of Justice in the Consumer Protection Division and a member of the California Access to Justice Commission.
All right. So Amos and Fariba, I don't know if you had a chance. I sent an email too late last night, kind of outlining what I was hoping to do today and with a mock-up of something Tara and I were working on last week. But I'm hoping it's all right with you if we get started with Tara, work through kind of the proactive regulation piece, and then transition to Tom and Jason, who are going to address that, but more as well. Okay?
That's great.
All right, Tara. Linda, is Tara able to screen share?
Yeah.
Okay, great.
I will do so. I think so. Okay, wonderful. Off to a good start. Okay, so hi everyone. Hope you can see my slides. And also the Word document that Leah attached, I think is going to be a great piece to actually discuss what you'd like to do moving forward using some of these principles. So what I'll do over the next 10 minutes or less is kind of just quickly explain why I might be here at the moment and what I've been doing with the California State Bar with the Mission Accountability Office and different other groups that are focusing with OCTC and on the attorney side of risk-based regulation, which I know is often interchangeable with proactive regulation. But here really looking at newly licensed paraprofessionals. So I've been working in risk-based regulation for quite some time. It's a concept that's very well utilized in the healthcare profession, specifically among physicians, where there's been a lot of evidence-based work, empirical work done regarding their performances. And I'm really excited about some of the work we've been starting to do with the California State Bar using that approach. And so that's why you hear about my health law background. That's really where it comes from, but there's lots of very clear parallels between regulating healthcare professionals and regulating lawyers. So in general, and I think Leah really said this very clearly in her email, was thinking about proactive regulation in terms of how the data comes in, and then, which is mostly through complaints with practicing attorneys, and then how to identify if there's potential hotspots, looking at characteristics of those complaints or demographic characteristics of the attorneys, and then developing interventions that could have hopefully a much more of a robust effect than otherwise if you're just kind of offering them randomly. And then of course to always evaluate the experience. And I think what's been quite new about what California State Bar is doing in this area compared to other regulators is really focusing on the complaining witness experience, which I know they're ramping up quite a bit. So this is work I started last May when I first met Leah and also Dag, who you may know at the California State Bar. And the work I did there was then summarized in this report, which we'd be happy to share with you, to the task force on the governance and the public interest. And then it was presented again this past January to the Board of Trustees. And the basic idea is to use data, in this case it is mostly data derived from complaints, to have a more proactive approach. So in other words, try to identify the forest before the trees. And in that way, just really be able to focus on how to prevent what could be causing a lot of frustration or a lot of complaints may be among complaining witnesses and help better inform certain high risk attorneys. So in that case, there are several interventions that we've proposed. And also what I think is important is to think about the client approach, because currently what happens oftentimes when a complaint is written is it's dismissed at intake. And so that can involve a great deal of frustration for a complaining witness who may or may not even may have been a huge effort to even complain in the first place, and then to not quite understand why it was dismissed or what could have happened, and then to not inform the respondent they even received a complaint. So that's something we've really been focusing on. So I just wanted to, I know that it's not always clear what exactly risk-based regulation, proactive regulation is. And it's certainly, I mean, in the age of COVID, maybe we're more familiar with like the public health approach to things. But the idea is that you want to build a fence. And in the case of California, it's such a large state with so many practitioners, you're probably going to be wanting to build lots of fences to prevent people from falling off a cliff. And what I'm proposing with Leah is the way to inform where you put those fences so you can proactively prevent potential harm that in such a new area for licensed paraprofessionals may be really inadvertently happening. And so the other benefit here is that it tends to be prospective and proactive. So this way we're hoping to get ahead of the curve rather than wait for a complaint to come in, think about things we can do right from the get-go, which we proposed in that Word document. And a lot of that involves types of toolkits and direct outreach, just as part of the first and third year with the licensing. And then the other idea is also right now it tends to happen with regulating attorneys is you either dismiss a complaint or you investigate a complaint and may or may not lead to a misconduct finding. We're really proposing a third option, which looks at really an education through compliance approach. So this is also based off some work from the healthcare field where, sanction is like the very end point of the game. And most of the time, even now, it rarely actually occurs. There's a huge amount we could do at the base of the pyramid in terms of working with the paraprofessional or the respondent and really engaging them early on to prevent careers in misconduct or other issues that could be leading to poor representation. So prior to my work in Arizona and with the California State Bar, I was in Australia for a number of years, and they had a really dramatic change in their law in New South Wales, where they were requiring all attorneys' practices that were law firms who became incorporated legal practices to engage in a really robust self-assessment. So there's been a lot written about what's happened there, because as attorneys went through this 10-category self-assessment where they rated themselves non-compliant on a scale of 1 to 10, non-compliant 1 to fully compliant 5, they actually saw a 2/3 reduction in complaints across the state in that group of attorneys that changed their practice to become incorporated legal practice. And it wasn't so much whether or not they were compliant or not compliant, it was just merely the process of really reviewing their business practices that caused such a reduction in complaints. So there's been a lot written about that work that happened in New South Wales and then was replicated in Queensland, and it's been written up in the Georgetown Legal Ethics Journal. It's really well documented, and that's what we're trying to discuss here today. So we'll be talking about self-assessments quite a bit. I have these different various blocks that we also tried to include in the Word document, where part of the reason it's so successful in Australia to have a self-assessment was that there was a triggering event. They had to actually go through this process, and it couldn't just be like checking off a box, because there was follow-up and they could be audited. So, because one thing Lee and I went back and forth on is like, would you introduce a self-assessment annually as part of the licensing renewal? But there's real danger in that, because you don't want someone to just discard it and treat it like it's a mandatory checkbox exercise, but to really engage with it. So one way you can potentially do that is if there is some type of interaction with the regulatory authority, whether it's through a dismissed complaint. We've also looked at reportable action bank matters for attorneys, just some kind of triggering event that could cause someone to want to engage more fully with a self-assessment process. And there could be other requirements that we can talk about in more detail, which we cover in the Word document. So this is happening in several states. Uh-oh, I think I'm frozen.
Are you? We were hearing you.
I think the video is frozen, but we could still hear. Yeah,
Oh,
there we go.
Okay, apologies. I'm nearly done. So this is going on in several states, these type of self-assessment checklists. The one in Illinois is mandatory for those that don't carry malpractice insurance. And so this is what it looks like, kind of looks like what my classes look like right now. There are online modules, there's checkboxes, it can fulfill MCLE. And then the other piece I wanted to mention, as we've been reviewing this whole process with complaints, because that still is where the most of the data is coming in from, is to make it much more granular in detail. So it's not just, was there a communication issue? What type of communication issue? What type of incompetence? Not just costs in general, but more specifically, how was someone feeling like they were being overcharged, or they didn't receive the retainer when they thought they should, whatever it might be. Because right now there's fairly broad terms that are being used in this area of data coding, like interference with justice, for example. And we're really trying to make it much more granular, because that's what could inform a more tailored intervention. So the idea is that you can collect data, and you will identify through these complaints, which I know you've heard about through efforts they're doing in the Utah sandbox, for example. You'll see like there could be these patterns where you'll have someone have lots of fee complaints among this particular demographic in this particular area. So the question after that, once you find that is, or if you find that, is then to do more of a case file qualitative analysis. We can actually do follow-up with thematic coding of the complaint, to think about how regulatory action might differ based if someone really had an intent to overcharge, or if there are more complicated issues going on, and whether that would involve a different regulatory or resource approach if the ultimate goal is just to have a professional practice. So I kind of went through that quickly, because I know you have so many things on the agenda, but the slides are available, and I will stop sharing my screen. How do I do that? This always takes me a second. Apologies.
And Linda, while Tara is working on that, do you think you could pull up the Word document that I sent last night?
Yes.
Okay.
Sorry there. Oh, there we go. Share.
So thank you for that overview. I have a basic background question, if you don't mind. It sounds like you're already consulting with the California State Bar about proactive regulation for attorneys, either in some sort of pilot. Is that already underway, or is that sort of a proposal for the future? Can you just describe that a bit?
Sure, it's already underway for reportable action bank matters. That's where there's been an issue with not sufficient funds in a trust account. And what had previously happened is dismissal letters or warning letters would go out to the respondent, or something more serious, but it often didn't include any types of resources, such things that we've included in this Word document, like an ethics hotline, legal counseling. So that's how we've already rolled it out with attorneys. And then we have several more that we're proposing right now to answer your question. So it's been an ongoing effort, but there's a lot of interest in doing it. And a lot of it's coming from the OCTC because they have such a large volume of complaints that are ultimately dismissed, and just how to view that work differently so that it's less work going through this process that their staff is dedicated to, so they can really focus on complaints that have real harm, but also a way to work with attorneys that up until this point didn't even know there was a complaint filed against them. So I don't know if I'm asking your question, but we're engaged right now, and we plan to do more work going forward.
Right. No, that is helpful. I appreciate that. And I understand how you describe that with that complaint procedure. I'm talking more on the not complaint based. So the self-assessments and the data collection over and above the complaint process.
Right, so what I presented to the Board of Trustees, for example, is looking beyond complaints. And that's why I was so interested in the reportable action bank matters, because it's an automatic trigger. So the bar is notified if an account is $50 or more in overdraft. And that's nice, because so often so there could be misconduct or serious harm happening, and then the bar would just isn't aware of it at all, right? It would never come up. So I was really looking at a way for a trigger that's already happening anyway, automated, that could be a sign of potentially other issues where there could be more engagement with the attorney. And
Tara, I think Amos is getting at the self-assessment question. And remember last year, the board did, that is, development of self-assessment is in this board, State Bar strategic plan. You did send me that related agenda item from last July. Are you aware, Tara, of what the status of that is?
I'm aware that they're building it to focus solely on trust accounts and trust funds, to have it, and I think they're trying to parse out whether it should be whether an MCLE fee should be waived, or could it be part of this requirement with reportable action bank matters that they would do that type of self-assessment. But they're still building it. It hasn't been built yet. They're working on the parameters around it. So,
and at the time, at the time I was aware of it, it was going to be voluntary, which is a little bit different, I think, than what we are contemplating here, potentially.
That's correct. It was going to be voluntary, and then I think they were even debating about how to make it anonymous, or at least the answers, and like maybe you completed it, but the way that you answered it would be anonymous. But I don't know if that's, I mean, from my personal opinion, looking at the research out of Australia, where this has been done several times and replicated, it's not even the actual how you rate yourself as being compliant isn't really the factor. It's the process that you go through. So there might, but you know, it's neither here nor there. But that's where that status is. And then, but I think they're really interested in rolling out more of these types of self-assessments. But right now it's looking at it being voluntary, or how to potentially incorporate it based off when they get the more granular detail with the complaint coding. Is that helpful?
Very interesting, and I think progressive and proactive, which I like very much. I think the narrow question we are really focused on is if in proposed regulations for a new licensed professional in California, if there should, in addition to what we're already working on in sort of updating the ethical rules that apply to California to how they would apply to paraprofessionals, should there be some form of mandatory reporting or self-assessments or audits or other quote unquote proactive regulation, which is what we're trying to understand, because it seems like that could be a lot of different things. Should that be built in? Now, I do think one option that we're the answer that we're coming to similar questions in other areas is, to the extent things are being developed by attorneys, if those come into being, maybe they should also be applied to paraprofessionals. So we could certainly do that. We could certainly do that to say, hey, if the bar is considering this for attorneys, make sure you consider it for paraprofessionals. But I think right now we're also thinking, is there anything we should be putting in our proposed regulation separate, to try to get it in advance of that, or to try to, be useful and address the concerns I think that we've identified about, competency and, excessive fees particularly.
Linda, can you scroll down in the document here?
Yeah, and just to comment on that, I think to get data, so for example, in the Australian study I was part of, it's a 10-year look back. It takes quite a long time to be able to really see like where hotspots of high risk could be emerging. So I really encourage this type of proactive approach where right away, as we proposed in the Word document, like the first year someone goes to renew their license and maybe their third, because that is a realistic triggering event. It's a new type of field. People are going to be much more aware and self-conscious about how they're acting. So I think that triggering event idea that I initially laid out in my slides, you kind of automatically have that, and you're not going to have data you can really collect and aggregate and drill down, for a while, I would think. So it's sort of a missed opportunity to not think about this, that the chance you have in front of you, which is unique to this new area.
In addition to the self-assessment, sort of having that as a regulatory requirement and initially, and then maybe year 3 of licensure, Tara had these interesting points about pushing some amount of mandatory MCLE, or at least offering it in the areas that we anticipate might be the most troublesome or difficult or challenging for the new paraprofessional. So I just, we kind of made some up and put them here based on the conversations we've been having. But certainly I think the authorized scope of the license is going to be a tough area where we're carving out, you can do X, Y, and Z, but you can't do A, B, C. And this issue of allowing paraprofessionals to practice together or with attorneys and fee sharing and all of that, that's probably another area worthy of affirmative MCLE supports.
Sure. I mean, even when I was looking at the complaints that attorneys receive, a fair number are in advertising, false advertising, and some of that may be to relate to your scope of practice. They just may not even be aware they're crossing the line, and this could just be helpful information to share with them in a way that they can receive continuing legal education for it. Any other questions or areas where I could clarify?
You guys are awfully quiet. What are you thinking?
I'm trying to form my question.
Oh, okay.
This is kind of a new area for me, so I hope my question doesn't come across really stupid and ignorant. But but I'm looking at your so self-assessment, triggering event. So self-assessment is totally subjective and ask the paraprofessional to be honest and forthright about themselves. And, I think what we're doing here is trying to keep the bad actors, as I've been calling them, out of this profession, right? Or at least get them to go on the right path. So then triggering event is either a client bring themselves to the point where they will submit a complaint. Self-assessment, okay, but what about the group of clients that are left out of all that? Because those who are left out because the paraprofessional may not be honest in self-assessing or may not totally not see anything, like you said earlier, until they, they don't even know a complaint maybe has been filed against them. They don't know if they're doing anything wrong. And then those who don't complain and they, they're left out there. Anything in your work that you have thought about that and kind of outreach to that group? Something that you send out, or I'm not sure how to even reach them because that's a client list, right?
Right. That's a great question. So to reassure you there, and I think it was a 3-part question. So,
Boy.
so maybe I'll start with the clients who don't complain, right? Which would certainly apply to lawyers as well. So that's kind of where you get to this idea where maybe we'll have areas that you think are high risk, the scope of practice, the potential overcharging. This paraprofessionals are required to do that at some point. So that tries to prevent, which could be a complaint from the clients who hopefully won't ever experience those issues because the bar's been so proactive in trying to prevent them from happening. At least they're making efforts to that, if that makes sense. So the other thing you could potentially do is you can survey. I mean, the way that they are now doing surveys with complaining witnesses at the attorney level is those that have complained, to survey them about whether they found the process to be fair and accessible. And there's a series of questions that they're being asked regarding that. And that's a way to even if the complaint ultimately was dismissed, not investigated, at least the complaining witness is feeling like they were heard, there was an appropriate response, or maybe there wasn't, but at least that data is being collected and hopefully responded to. So that would be that. So I guess you have your different categories. You have people that aren't complaining at all, but maybe harmed. How can you help them? And then you have people that are complaining. How are you effectively responding to them? And then is there a third? I feel like there's a third question in there too.
The self-assessment piece. Yeah.
Right. So, in the Australian experience, it was, you're right, it's entirely reflective. I mean, you could make it more robust, I suppose, by having them include certain documents that show that they have a diverse inclusion hiring process, or whatever it is you're looking at assessing them for. I mean, you could require documentation to support their claims. If you want to make it more robust, particularly in certain areas, you could potentially have them file with self-assessment how they disclose their fees to clients. So that's one.
Perhaps that they wouldn't be facing negative implications if they are truthful and honest about self-assessment, that this is a tool used to help them improve their performance, kind of, right?
Right, and that really was the setup in Australia. It was presented as through compliance. It really was meant for, we're going to provide you the templates, the tools. We know this is new. We're not here to sanction or discipline you. We're here to be a resource for you. And that's how it was set up. And I think that's why, for whatever reason, how people actually rated themselves, which for the most part, people rated themselves 3 or 4 in those categories. Like, it didn't really have any real meaning to anything anyway. It was just, what they really looked at to see if self-assessment was overall having an effect was what did the complaints look like down the road. So, I mean, you're in a sort of interesting situation when you don't have a baseline yet. So you don't really know if the work you're going to be doing is how you don't have something that you're evaluating it against. But I think, so it's something maybe to think about, actually, if you want to experiment with it more and how you roll this out, whether you want to do it across the state or in certain areas. I don't know if you want to, how you want to play with empirical data there, be more experimental. But they really set, just to give you what's been done so far, it was absolutely set up as, you are required to do this because you're changing your type of practice, and we have real concerns about ethical issues when that happens, but we don't really, it's not an issue so much how you weight yourself, but to please access these resources in the process of doing it. And that seemed to be what needed to be heard. The ultimate messaging was that we just want to know where to access the templates, how to think about our business structures that cause such a reduction in complaints, basically.
The thing I wanted to add, Fariba, is I think that, getting at that issue of the clients that never complain, that takes us over into the other kind of proactive regulation we were talking about with Tom Clark, and he was talking a little bit about the Utah sandbox. And I tried to put in my email, have been struggling with these different definitions of proactive regulation, because that approach would require the paraprofessionals to give the regulator a client list. And then the regulator would have to go out and find all these clients and ask for information, right? The auditing is another one that I think falls in that Tom Clark proactive regulation. And so I think those are a little bit more intrusive and burdensome than this approach, which mostly uses complaint data, other data that you have, the self-assessment, in order to try to provide affirmative support. So I think they're kind of maybe different parts on a continuum of proactive regulation, some more interventionist than others, and more burdensome than others. But I think that's the only way you get at clients that never complained, is getting client lists and trying to go find folks.
And of course, the other thought as I'm listening to you is that if you at least do this piece of it, it may have a positive impact overall, and that the clients that you don't reach, or there'll be fewer clients that are harmed had you not even have this effort altogether.
There's another option other than sending client lists to the regulator and having the regulator reach out to them. You could the regulator could set up a questionnaire that's at a certain place, and the requirement could be that the paraprofessional is required to send all of their clients a link to the survey to complete, and then the regulator sees the survey responses.
That's what Amos and I have been sort of working on, what to include in regulations, in disclosures and disclaimers, and all the information that they're mandated to provide the client before they sign them on, or on during representation. Representation, I suppose. I'm not sure what to call it. So.
Can you scroll down a little bit more, Lynn? I just want to make sure. So one component of this model would be targeted MCLE, sort of affirmatively offered. Another component would be the self-assessment. And then another recommendation from Tara that you're scrolling too far, that was really good, was to be at the onset in the construction and design of the program to ensure that you're capturing a lot of data when those complaints do come in. Because one of the challenges they're having on the attorney side is they're having to try to get more data in order for the data analysis to be useful. Then other components would be just to recommend that there's an ethics hotline available for paraprofessionals the way there is for attorneys. Keep track of how folks are or are not accessing resources, and then the self-assessment. So I just wanted you to know those are like all the components potentially, at least we've come up with so far. And a client survey could potentially be another component.
Yeah, that's great. And I should say at this point, the client survey was introduced maybe 6 months ago, and they have about a 20% response rate. So, and when you are thinking about the design of some of these tools, to think about how you would get response, like how you would increase the response rate, or what that might look like so that it wasn't too burdensome for someone to fill out a survey, reduce your chance of biased data. So it's not just someone who had a horrible experience, but maybe people that actually had a good experience with their paraprofessional as well. But I think what's been so interesting about regulating attorneys up until this point is that, and this happened in Australia as well, is there was so little information about the complaining witness. Really hardly anything other than what the complaint was about and maybe their name and background. You have no idea how many times they filed a complaint, how vulnerable they might be, unless you read about it in the complaint that they were in prison or immigration issues. And so I think this way of just being more proactive with where complaints are coming from and how you're regulating the resulting paraprofessional will be extremely helpful. And that hasn't really been done in this space globally. I think it's a really nice change and turn in how things are working. And one thing they do quite a bit in the healthcare field is there would be discussions, between doctors and patients about the care that was received, whether there was an issue with it. And that's potentially something that we can be doing more in the legal profession between complaining witnesses and attorneys is to have these committees or interviews set up where, you know, there's a chance for the client to better understand what happened, a chance for the attorney to learn how the client may have felt. There could just be that's something that is done regularly in between physicians and patients that could be something we could introduce here as well, which is a possibility.
Thank you very much. That was very helpful and informative.
Do you all, what would be helpful, Amos and Freba, to you to move this part of the conversation forward in terms of, is there anything you're settling on that you might actually want to recommend?
Yeah, I mean, I think we need to discuss it more. I just think we have a limited time because I also want to hear from the other speakers that we invited.
Okay. All right.
So maybe, I don't know how much time we'll have left in this meeting to talk through it, but I think that's a lot of great information that we can discuss. I really appreciate you coming.
All right, great. So
I want to take more in and then maybe have a discussion when we have time.
okay. Thank you so much, Terry. Appreciate it.
Thank you. Very helpful.
Oh, yeah, thank you. And I'm happy to be available via email to follow up if needed and provide, there's many articles written about this self-assessment approach. And if more information is useful, then please let me know.
Thank you.
Bye, take care, everyone.
Thank you. Bye-bye.
And Linda, you could probably stop screen sharing. All right, Tom and Jason.
Okay, I don't know if you'd prefer to hear from either of us first, or I'm happy to kick things off. All right, great. So I will try to keep my remarks brief and sort of in outline form, and want to give you guys plenty of time to follow up with any questions you have. Just to reiterate, I'm Executive Director of Responsive Law, and we're the only national organization looking out for the interests of consumers of legal services. So that gives us a lot of insight into what consumers actually want when they're trying to get legal help. There's two overarching principles, I think, that really should govern all of this decision making. One is that consumer protection should be based on actual consumer needs, not lawyer perception of consumer needs. And we've all been through law school and through our careers sort of indoctrinated in certain things being essential to consumer protection, when in fact, that's not always the best way of protecting the consumer. The other important thing is that in order to maximize the access to legal help that people have, paralegal providers should be regulated on a level playing field with lawyers. That there's a lot of great ideas for consumer protection that are being proposed here, and some of them are new, and some of them might not put too much of a burden on access by imposing too much of a regulatory burden. Some of them would be great to also recommend as new additions to the regulatory system for lawyers as well. So I think, you know, everybody realizes by this point that we're in a crisis of legal needs because the pandemic is increasing people's legal needs, and it's making it harder for them to afford help at the same time. You know, I think we're all aware of the increasing types of legal needs that people are dealing with in housing, in employment, in benefits for particular COVID programs. And so right now you have a dichotomy between people who can afford a lawyer. Most of those in the category of those needs are not getting help from a lawyer. They can't afford it. That leaves them getting help from wherever they can find it. And that often comes from family, from friends, from information on the internet, for better or worse, or just going without and trying to push through the system. And consumers would certainly welcome some sort of experienced, competent help, whether it's an affordable lawyer or someone else with training and experience that can help them navigate a system that's bewildering to them. And so it's important, of course, to make sure that a new profession is, people are protected from any problems that may arise in a new profession, just like they are protected from malfeasance or negligence from lawyers. And there's, I think, really 5 buckets that protection comes in: licensing, financial responsibility, a discipline system, information and disclaimers, and then the generally applicable legal protections that apply across industries. So just running those down briefly, in terms of licensing, I think having something far closer to the Ontario model than, say, the Washington State model for the licensing bar that needs to be cleared is really crucial. Washington State was really designed to fail, whether on purpose or by accident. A system that put that high of a burden, that puts you 2/3 of the way to becoming a lawyer, is not going to create a marketplace for a more affordable type of legal help. Ontario, on the other hand, has a much lower bar, still sufficient to ensure that people are adequately trained, and is now a robust market with, I believe, thousands of paralegals providing services. Jason, I believe, is going to talk a little bit more about another idea for really lowering the burden and reaching more people. So I'll defer to him on that. In terms of financial responsibility, the second of these areas of consumer protection, I think it's important to ensure that consumers can be made whole to the extent possible if there's anything that goes wrong. I think the choice between a bond, I know that one of the issues being debated is whether to go with a bond or a malpractice insurance requirement. It is worth noting that lawyers aren't required to have malpractice insurance. And at the same time, malpractice insurance does provide some level of protection. I think looking at other ways that we can protect consumers in the system is important. I think some of the things that Tara was talking about could also be helpful in that way, that if you can show another way that you're ensuring that consumers are going to be protected against, that they're going to be made whole, that can be useful as well. The third point, disciplinary system. One point I want to make is also in governance of all of this, especially in a disciplinary system, this should definitely be regulated with consumer voices as part of the regulation system. That having it just as lawyers regulating another profession is going to bias a disciplinary system, and things that might be seen as problematic by lawyers might not be seen as similarly problematic by people who were disinterested in the outcome of a disciplinary case. Also, I think that also ties into some of the issues that Tara brought up about data. I think that's a great approach to have data collection about disciplinary complaints. And I think anything that the committee proposes to apply here could be set out as a model to apply to the lawyer system as well. That's going to be really important in a lot of areas where you're collecting data, to have comparable data. So you don't just look at a data system that says, oh, X% of paralegals faced a complaint in the last year. Well, what's the number for lawyers? We probably have that number, but we may not have some of the more detailed numbers in other areas. Fourth point, disclaimers. I think it's important to have fully informed consumers. So letting a consumer know what a paralegal can and can't do, understanding that scope of practice is important. And for the most part, I thought the draft disclaimers you had, I believe it was in your December memo, were really well thought out. There were a few places where in the informed consent language, I thought it was a little bit straying into the marketing for lawyers category rather than full disclosure. And so I think it's important, for instance, to mention, certainly you can mention you may be eligible for legal aid if you can't afford legal help. On the other hand, mentioning things about the risks of agreeing to a paraprofessional or the risks, the potential need to hire a lawyer. I think those were sort of vague and seemed to be threatening to, I think, would leave a consumer feeling that they were getting something that was subpar and somebody that was not competent and may not provide service as good as a lawyer. So I think making sure that there are disclaimers that show what the limitations are, but at the same time, don't say you're receiving something less by going to a paralegal, are very important. Finally, it's important to keep in mind that in addition to whatever protections we put in through new regulation of a profession, there are existing protections in existing law. So consumers in any area, including dealing with lawyers or paraprofessionals, are protected by tort law, by contract law, by consumer protection statutes, and by the marketplace that is going to react pretty harshly to someone who consistently provides subpar service. So that's I think, the outline of the areas that are important to make sure you're keeping in mind that will maximize consumer protection, but also maximize access at the same time. And I'm happy to answer any questions you may have.
So very helpful. Thank you for coming. From reading your article, it was clear that you've given this a lot of thought, and your presentation here as well confirms that. I have some specific questions, if you don't mind. And if obviously if you haven't given these specific areas thought, totally understand. But a couple, I think your audience here agrees with you strongly that there is a market for lower cost, more available legal services from non-attorneys. But the question presented to us specifically right now is, what regulation should we be proposing? And so it sounds like you've seen some of our work. If you have specific recommendations on language, particularly for the informed consent, please feel free to mock that up and send it to us, because I think you're right. I don't think we want to be too negative, but we do want it to be informed consent, and that does need to, I think, or at least the draft language, which is still draft language, have an understanding of what is the difference between a paraprofessional and a lawyer. What are the risks? The benefits might be the cost, but there might, so it's tricky. And so if you have specific ideas on that, but the other areas where I think both your article and your comments here suggest that we probably need to think hard about what regulation might be appropriate is, dealing with competency issues and dealing with the risk of excessive fees, and maybe, advertising concerns, false advertising concerns. So do you have any specific suggestions for how we might be able to regulate with respect to those areas?
Yeah, I think competence, can be dealt with in a few ways. I think, making sure certainly through the licensing process you have an examination or an experience requirement. I think in terms of, I think, again, you could probably do a lot of that in the alternative where you could have experience substitute for a licensing exam. The one part that I know has been discussed is perhaps a must-have that can't be experienced out of is scope of practice restrictions, which seems to make sense. But for the most part, I think having, like I said, I think the Ontario model is a really good model and seems to work there, and that's what I would want to see something come close to in the competence area.
How about for ongoing? So let's say there's license requirements in terms of education or experience. I think, and we have a separate committee dealing with that, but that is something that we're certainly considering. But the question is, we are talking about MCLE requirements, but beyond that, I don't think we have anything specifically to deal with competence. And that's why we were talking about proactive regulation as well, something going forward to sort of cut it off at the pass.
Mm-hmm. Yeah, and I think, given the choice between, say, proactive regulation and either MCLE or re-examination or something of that sort, proactive regulation makes a lot more sense. It's much closer to what the consumer needs, and is going to show where the actual harms come from. And maybe in practice, what happens is that CLE is the solution to hitting all the marks you need to in proactive regulation, but more likely other things may do that just as well. It could be that actually practicing in those areas leaves you competent, that you'll spend your time actually working in the areas and researching and reading on your own rather than sitting in a CLE class and doing whatever you need to do to check that box.
When you say proactive regulation, what do you mean? Do you mean the auditing and kind of going out and affirmatively getting data that we don't currently have, or do you mean the self-assessment, using complaint data to develop tools, kind of proactive regulation?
It could be either. Frankly, I think either one is better than trying to come at this, really the long way through CLE. That's not focused on consumers, just focused on really checking a box. So I think I'm a bit agnostic right now as to which of those approaches is better, except that I think probably, given the fact this is a new program, it makes sense to start it off with a more lightweight type of program. I think trying to get all the bells and whistles you have with a Utah-style sandbox is probably too much of a regulatory burden, both on the profession and on the regulators at this point.
And how about excessive fees, the concern about overcharging, particularly in the context of trying to develop, increased access and a lower cost alternative with this model? We haven't yet figured out beyond potentially upgrading and having more extensive disclosures, which is one of the buckets you talked about, and that might be a way. But do you have any suggestions on how we could potentially address that?
I really think the market's going to take care of that pretty well. I think no one's going to say, I want to go to this paralegal who's going to charge me $500 an hour. That doesn't seem like the way the profession will be likely to market itself. And I think having having transparency about price is important. So I think one of the things if I recall correctly, you had a written fee agreement requirement. I think that's really useful. Again, not always required of lawyers, and I would certainly recommend you put in a little nudge in your final recommendations that lawyers adopt that too. But I think that's a great way to ensure transparency, and someone will see a dollar figure and say, oh, that may be too much. But it's not giving consumers enough credit, I think, to try and figure out what you can do to hold fees down for them. I think one of the things you could end up with if you try and set fee caps or fee schedules is something like, we've all seen, the EOB from our insurance company when we've had some sort of medical procedure, and we know that's a small glimpse of the thousands of different allowable payments you would have for different areas of practice. And you could have the same thing trying to regulate every single possible permutation of experience and difficulty of issue and scope of activity. And so I think it's just asking for too much trouble and really just unnecessary, when the market will take care of that.
Okay. I was just going to say, I really appreciate your comments. Very helpful. I think both verifying work that we've already done, but also thinking through the issues that we're still grappling with. And I would be very interested if you have specific suggestions on the draft disclosure, the written agreement or the informed consent or any of those. Those are still very much drafts that we are very open to comments on.
I'll pass some along too. Absolutely.
And Amos asked some of the questions I had as well. And thank you very much for your comments. I'm enlightened by your comments. I just want to mention that the committee has approached the various issues we're tackling from the standpoint that these clients, these consumers, are more at risk, less sophisticated, and need more protection than those people who can afford to hire attorneys. So to the extent that the licensing requirements may be too strict, too burdensome, like a Washington model or Ontario model, to the extent that the language in the disclosures and disclaimers are way too much, and in a way perhaps disparage the paraprofessional profession, and kind of telling the consumer who's signing it, hey, are you sure you don't want to hire an attorney? So we are sort of approach it that way. What I'm hearing you say, and the fee schedule, the topic of the fee schedule. So I'm hearing you say that, yes, they need some protection, but you may be going too far. Am I understanding you correctly?
I think so. And I think one way to look at it is to say, look, I'm sure, as with any service profession, there are going to be bad actors, just as there are bad actors among lawyers. But we don't have, for lawyers, requirements even of written disclosures of any kind, let alone ones that say, hey, I charge a lot of money, you might be better off with a paralegal. And if those were in place, I'd feel a little better about this coming from a place of actual consumer protection. But right now, it seems to be a very one-sided way of saying this profession is less than, and therefore you should really, really consider having a lawyer instead of a paralegal.
But you're also not recommending that it mirror the attorney regulations system word by word, that there are some protections that this group of consumers need, but not as much as we've thought of, right?
Well, I wouldn't say it's a group of I don't think it's a group of some protections that this group of consumers needs specifically against paralegals. I'd say they need it in general. And while we may not get that included for the language we use or requirements we have for lawyers serving that group, I think this is a good place to start getting those protections in place. So in that case, it might be uneven only because the opportunity is presenting itself here to have a fairly lightweight regulation that will not burden the profession significantly, but will provide that protection. We'll work on getting that for lawyers later, one problem at a time.
Yeah, and that's my last point. Sorry, Ms. That's my last point, is that we also approach it from a best practices perspective, because we have learned some things from our current system, and why not, start this brand new license professional program with lessons we've learned, and then have fix the attorney discipline and licensing system.
Right. Yeah. And if this all goes well, this becomes a model to say, hey, the lawyers, hey, this has worked really well in the paralegal context. Why don't we consider adopting this for the bar as well?
Thank you.
And Fariba, to further answer your question, I think, and that's why I invited Tom to really get down and dirty in the documents, because it might be language choice, or maybe being able to put more benefits in addition to risk language, because it might just be our bias coming at it from a risk point of view, or from a less than point of view, when there might be a way to still do a disclosure and an informed consent process that doesn't have that marginalization of the licensed professional, which I think we should definitely be open to. I mean, I think the consumer protection angle is why we're doing it, but we might be able to do it in a way that doesn't have those concerns. So that would be.
I agree. I think we have learned, I definitely know I've learned a lot since we first met and came up with that language. So I agree. Thank you.
Okay, should we hear from Jason? All right. Thanks, Tom.
Great. Well, thanks for having me. Thanks, Leah, for inviting me. Good to meet you, Amos. Good to see you again, Fariba. I don't know if you'll recall, but you hosted Margaret Hagan and I in our class that we taught on eviction down in the courthouse, which was terrific. Thank you so much.
Oh, what a small world. Good to see you.
And I really appreciate all the work that everyone's doing on this. So let me share my screen, and I will talk for 5 or 10 minutes about a few things. And I'm going to kind of take a little bit of a step back. And I know you have very kind of concrete things that you're working on. So bear with me as I kind of step back and be a little big picture. But I promise that it does have some implications for some of the things that you're talking about both today and at the last subcommittee meeting, which I did observe. So I want to just talk a little bit about how the work that you're doing in terms of regulating paraprofessionals figures into the overall strategy of closing the justice gap that the State Bar is working on, and the Sandbox Working Group and all the post-ATILS work. So the general post-ATILS work, right, is partly about rule changes, including rule changes to what lawyers can do. Advertising is a good example of that. And then a lot of it is experimenting with new providers. Now, we're going to see that in the sandbox with experimenting with things like non-lawyer ownership of legal services providers, possibly narrowing of UPL in certain circumstances, and then the paraprofessionals issue that you all are working on. One big point I want to make here is to think about different strokes for different folks. And what I mean by that is that different populations with different problems may mean different strategies for how to close that justice gap. So people in family law, for example, are people who don't necessarily have financial pressures, but they're people going through hard issues like child custody and divorce. People facing eviction, on the other hand, are people who are facing serious financial pressures. And so that may mean a different strategy for them. And so that's a big point I want to make, and you'll see how that plays out. I think the mental model that you all have been talking about, which makes sense in terms of how paraprofessionals are going to work, is essentially as solo practitioners, kind of one-to-one working with clients. But to a certain extent, the present and certainly the future is of these kind of more one-to-many models where lawyers leverage technology, process, and allied professionals in different ways to provide broader services. And that's where we're really going to see significant progress in terms of closing the justice gap. And as you may recall, some of you may know, the whole ATIL's work started with this report on the state of the legal market by a professor named Bill Henderson, who really emphasized these one-to-many models as the way to really make progress in closing the justice gap. So I have up here on the screen a shot from something called Hello Divorce. I don't know if you know about Hello Divorce. Started by a woman named Erin Levine, who is started a solo practitioner in the East Bay. What she has is a platform that uses a subscription-based model to offer some different levels of service to people in family law. And what she does is she uses technology, she uses paraprofessionals, specifically legal document preparers, and she uses lawyers to give people affordable legal services in the area of family law. So when we think about the future, and when we think about how services are provided, and when we think about how the paraprofessionals that we're going to be authorizing are going to work, some of them are going to work for Erin Levine. Some of them are going to work for Hello Divorce and other providers like it. And that has implications, I think, for how we think about these regulatory issues. Tom alluded to this, but I want to just refer briefly to another model that's probably not specifically in the scope of the paraprofessionals work, but is something that either the Sandbox or the Paraprofessionals group is probably going to have to consider before too long. One title is Community Justice Helpers, and this is the model of having people who are based at nonprofits, based at community-based organizations, be able to offer limited legal information and advice without having to worry that they're going to be hit with a UPL charge. So what I have on the screen is this pilot program from a group in the Bay Area called Legal Link. And what they're doing is they're partnering with social service providers, health clinics, homeless providers, and they're basically providing these people with legal training. So they're not licensed, but they are trained and they're certified that they're trained. And they're able to provide some kinds of limited legal information. The New York task force that essentially was the equivalent of ATILs just came out with a report in December. Their primary recommendation focuses on social workers as possibly people who could get this kind of training. Again, it's not even clear from the report whether they're going to be licensed the way we're envisioning for paraprofessionals, or just kind of receive some kind of training and certification. But that's the primary recommendation there. And again, this could be a model, this community justice helpers could work better with some of the very poorest people who, for whatever reason, aren't able to get legal aid services, but also don't have money to pay a paraprofessional. Finally, a few thoughts on the future of regulation. It's going to look a little more, I think, like the FDIC and less like the DMV in the following ways. Number one, it's really going to be entities that we're regulating, not as much or not exclusively focusing on individuals, and it's going to be focused more on the risks and less about the rules up front. So what are the implications of all this? Well, one thing is, I do think, back to the different stroke slide, we need to think carefully about what are the best business and service models that are likely to work for different kinds of problems and different kinds of populations. We need to connect these post-ATILs efforts to one another. Out of the regulatory sandbox effort, I think we're going to see a lot more models that look like Hello Divorce. And as a result, that means that these people we may be authorizing are going to work in different settings than we're used to. So for example, going back to the last subcommittee meeting, when I know you were talking about this issue of should paraprofessionals in advertising have to disclose specifically that they're paraprofessionals and they have limited things. And I know the issue came up, well, what if they're in firms working with lawyers? Does that mean that when a firm advertises services, they have to include a specific thing about paraprofessionals? You know, that's going to be, again, an issue with something like Hello Divorce. If you think about family law paraprofessionals working at Hello Divorce, Hello Divorce just advertises, hey, we're Hello Divorce, come to our website, go on our app, check us out. So, they have lawyers and they have legal document preparers, and they're going to have family law professionals if you authorize. So what does that mean? I mean, in my view, it speaks to a little bit, keeping it a little more simple. So for example, I know there was at the last meeting the question about whether to sort of have that issue about what a paraprofessional needs to disclose, whether to put that in a comment or whether to put it in the text of the rule. I think this approach would weigh for putting it more as a comment, and just saying, look, paraprofessionals don't make false and misleading statements, period. On fees, same as lawyers, don't have excessive fees. Someone wants to complain about excessive fees, someone wants to complain about false and misleading advertising, State Bar will investigate, we'll make a call. That's what I think, because we just can't predict the various settings and the various ways that these paraprofessionals are going to operate. All right, that's all I got. Happy to talk. And I will stop sharing my screen.
Jason, if you can send a copy of that to me, I'd like to add it to our Dropbox.
Great.
Thanks.
I figure you just want the different strokes photo, because that was a good memory for you, Linda. But
for those of us who are old enough to remember, yes.
Oh, yeah. No,
I think I'm too old for different strokes.
Oh, there you go.
That? I'm way too young. No, thanks, Jason. I think, I don't know if I've given enough thought to this concept of truly the differences we will have in practice, and that we're licensing this new group of professionals who can go out there and provide their services in different ways. I can speak for myself that I hadn't considered the full gamut of ways they can provide services. So thank you.
So yeah, this is very helpful, and I definitely agree. There is some overlap and some tension between trying to separate these various initiatives the bar is doing. I think, and maybe at last meeting where you observed, but in some prior meetings, we've sort of, I think, tentatively taken the approach that we want to move forward. We're on a faster timeline, so we need to go ahead and do our work, but we also don't want to, undermine or get in the way of the other, closing the justice gap group that is, doing some even more difficult and controversial potentially things, but trying, different approaches. So I think, at least for me, the mindset is we're focused on paraprofessionals, and we are tasked with what regulation is appropriate to protect the public and consumers. And so again, I sort of come back to the practical question of our direct task ahead of us. But I agree. And I think, by the way, the New York Navigators are a great model that I don't know if it fits in any of the stuff that's currently being contemplated, but I think it's a great model that we should consider. I just don't know if it's under our task right now. So really, I think for what we're contemplating right now, how do we regulate a lot of what we're doing is let's do it the same as lawyers effectively. And to the extent, the bar is going to be considering changes to how lawyers are regulated, let's make sure you consider if those changes are appropriate for paraprofessionals. So it sounds like you agree generally with that approach. Is that fair?
Absolutely, absolutely. And I think, like Tom, I think the example of, a written fee disclosure as one way to further the transparency and predictability of fees, which I think is really more the issue than excessive fees. I think, as Tom said, people who are looking paraprofessionals, I'd be a little less worried about the excessive fees, but it's really, again, a similar issue as to what the consumers of lawyers face, which is the transparency and predictability of fees. And I think a written fee disclosure is a good idea that, you could try here, and maybe down the road, State Bar might take it up for lawyers as well. Similarly, I'm also familiar with the self-assessment approach of New South Wales, and that's terrific. And I'm glad you have Taryn to talk about that. I think that's a great approach. So trying that, I think, is a great idea. I think recognizing it, as I think you know, and certainly the state bar staff can tell you more about, that the complaints and the issues that mostly arise in legal services are more around, what the Word document referred to as kind of business management practices. So whether it's management of the money or missing deadlines, it's sort of, organizational kind of things, as opposed to, this person didn't know, this area of family law well enough, or things like that. So, I think the other thing that I'd say is, and so when Amos, you referenced earlier kind of competence. When I think about the competence concerns that I would have, both frankly for lawyers and for paraprofessionals in this context, it's more those things, those kind of business management practices and organizational practices, as opposed to things like, are they going to know what to do if they end up being able to go before court, or are they going to know the issue of the specific area of family law well enough? I think, we have good enough research from the UK and Canada about how well non-lawyers, some of whom are paraprofessionals, do versus lawyers, that the outcomes generally are comparable or better. Consumer satisfaction are comparable or better. So I don't think we need to be just worried about those things, more about the kind of business management practices, that sort of thing.
I'm interested both for Jason and Tom, if you, since you specialize in this area and have a lot of knowledge, if you are familiar with some of the issues and concerns that have come out of like immigration consultants and practices and maybe other non-attorney practitioners, or people who do legal like information, or notaries that practice, although that could fall within the immigration consultant. But if you have information about issues that have been raised in those areas, that might again inform us on how we might propose regulation.
I'm happy to start, Tom, unless you prefer to, but
Go ahead.
Yeah, I mean, I don't know about immigration consultants specifically. I know a bit about notarios and some of the concerns that have been expressed about notarios, for example. My basic reaction is, great, that's an argument for regulation, right? These are people who are unregulated. And, a lot of what I see in terms of the various debates over the closing the justice gap stuff and all this stuff that the different working groups are working on is, there's an unregulated sector that's continuing to grow, which is providing legal services of various kinds, whether it's notarios, whether it's LegalZoom, it's all kinds of stuff. And then there's a regulated sector. And I think to the extent that we have concerns, it's an argument for growing the area of the regulated sector. And so, in the immigration context, for example, I know a bit about accredited representatives who are non-lawyers who are able to appear in immigration court. And I think that works pretty well. And where there are things like, notarios, my argument would be, well, let's, bracketing whether the people who are notarios specifically, we should subject them to more regulation, but let's have more kinds of affordable legal services providers who are regulated in some way, such that if problems come up, people have a mechanism for making complaints. And, the regulatory agency here, the state bar, that has the authority to do something about it, can do something about it. So that would be, that's sort of my basic approach to that stuff.
Yeah, I completely agree. I think you've got this gray market that is serving some people well. I mean, not everybody who's a notario is a scam artist, but it's an environment that allows scam artists to flourish that wouldn't happen if this were a regulated market. So let's bring them in.
I just so you know, I 100% agree, but I think the difficult question is, now we're creating a regulated market. What are the regulations? So if we have a regulated market, but there's not really regulations designed to address some of the risks and public, protection concerns, then we haven't solved anything. We've just, legitimized it in some way. So I think a lot of the concern is yes, let's create this regulated, but have effective regulations. And that, again, I think there's a tension because over-regulation isn't a good thing, but under-regulation isn't either, or you're not really solving the problem.
One thing that
Yeah, I
occurs
think
to me
I-
also,
go
I'm
ahead.
sorry, go ahead, Jason.
No, you go.
One thing that occurs to me specifically in the immigration area, but could be generally applicable, is when you're having written disclosures and written fee agreements, make sure that the requirement is that they're in a language in which the consumer is fluent. So you're not talking to somebody in Spanish and then handing them an English document that they may or may not be able to read well.
Absolutely, absolutely. And I incorporate at least in our draft, that language as well.
Yeah, the only thing I was going to add is I hear you, and I'm happy to talk about any of the specifics again that you're dealing with about the need to design regulations that are best suited to minimize. I think one, there's a question of how much you can draft rules that will have an effect on deterring either bad actors or just negligence or whatever. And I think to a certain extent, although I know this is not, super comfortable, it's not super comfortable for me even saying it, but you have to a certain extent be okay with the fact that there are going to be some bad actors, there are going to be some not great people, just as there are with lawyers, but we can be confident from the research around the world that they're not likely to be more negligent, more bad actors than there are for lawyers, and to just put in place the mechanisms whereby you can have the kind of interventions that Tara was talking about early on. You can make sure to have a complaint process that's going to be quick and react and be able to intervene. So that's part of how I might think about it.
Yeah, it's very helpful. And I know, sorry to put you guys on the spot with these questions, but I think this is where we ended up. So again, if either of you have comments specifically on, because we really ended up on having some sort of financial responsibility, having some MCLE requirements, and having some written disclosures and informed consent. And we don't want to make it too burdensome. So, with an eye towards, is this too burdensome? Is there a way to get to the result by minimizing the burden a bit, or changing the language, or not being sort of coming from a negative place, but still getting to the disclosure regime, if you will. And I think we're still just struggling if there's anything else that we're missing that we can and should be doing. Whether it's in the going forward, mandating something of self-assessments or other CLEs, or whatever it might look like. But it sounds like, I don't want to put words in your mouth, but it sounds like you're generally comfortable with what we're proposing so far. Both of you seem to be concerned, and I think rightly so, that we not over-regulate or overburden, and I think that is absolutely fair. So I really thank you for coming in. If you do have specifics, and maybe we can forward sort of our drafts if you don't have them handy, but if you do have any comments on what we might be, where we may have gone too far in our proposals, or where we might be able to add in some disclosures or protections, I think that we would value your input.
I just wanted to ask, I heard you, Jason, say that you're not familiar with immigration consultant legislation. I was wondering, Tom, if you are familiar with that legislation and know how detailed the legislation is, and how it regulates truly like the font of the contract and all that. And I think to a certain extent, the average consumer that uses immigration consultants is probably more vulnerable than the average consumer for these paraprofessional services. I'm willing to admit that. But what is your opinion about that legislation, and why shouldn't be following that model?
I mean, I'm not super familiar with the specifics and that it requires font sizes to be a specific thing, but I think, again, that can be simplified, much like, advertising rules go into far too much detail and can really just be summed up as don't make false and misleading advertising statements. You can do the same thing. This should be legible to the average person. If the average person can read and understand it, that seems like an adequate disclosure. And the rest could be in comments, but certainly doesn't need to be part of the rule. It has to be in a certain font size.
Mhm.
And Freba, I would just add that one of the issues with the immigration consultant is they are regulated, if at all, by the Secretary of State. That's who maintains the evidence that they've satisfied their bond. But there really is no true regulatory oversight. And, filing a complaint and getting it investigated, we've just heard over and over again that it doesn't happen. So I do think it really goes to perhaps there might be legislation which specifies what needs to happen, but there really isn't any oversight body that can enforce it. So I think that is a fundamental problem there. And the same thing with LDAs and UDAs, frankly, which register with the counties. And, the counties don't even maintain a list of who's registered as far as we know.
I have one final question for you, to just your opinion in terms of comparing lawyers and paraprofessionals, and how there's data that shows the results are not likely to be different or better using one versus other, consumer satisfaction and so on, similar. But all the things we have to go through as lawyers, 4 years of law school, bar exam, all the licensing requirements, CLEs, and just for me at least, I want to follow everything. God, I don't want to be, disciplined or anything like that. But you make it too easy, then you get a lot more people. So I tend to think that having so much regulations, having to go through so much, it'll sift out people who are in it for an easy buck. The bad actors, if you will. But I've certainly seen enough lawyers who've acted badly, don't get me wrong. But do you think that is a way to look at this, to kind of leave out the people who are just in it to make, to abuse people and just in it for the money, easy money?
I think if you wanted to make easy money, having a CLA requirement where you certify that you sat there, or where you sit there and, work on something else. I mean, I remember sitting in a CLE and watching a state delegate sending out fundraising letters, sitting in front of me and paying no attention. So, I mean, you can do, CLA requirements, I don't think have any correlation to how well you're going to serve your customers. I don't think the idea should be to set a higher bar to get rid of scam artists. I think the idea should be to figure out what is going to protect people from scam artists, rather than setting a bar that's going to keep a lot of other people out that could provide services.
Okay.
Yeah, I mean, my reaction is just thinking about what of all the hoops that you had to jump through, that we all had to jump through, but what is important and what is not. I think the experience requirement for paraprofessionals is very important and is an important thing. And I think having paraprofessionals specialize is very important, because the research shows, and what, when I said that, comparable performance with lawyers and non-lawyer paraprofessionals, I should have said with the caveat that that's not in the most complex cases, right? So it doesn't apply in the most complex cases. And also, it's assuming that the paraprofessionals and non-lawyers specialize, which is generally the case. So I'd be a lot more worried about, for example, the competence issue, Amos, that you've raised on a few occasions, if we were authorizing paraprofessionals to be generalists, the way we do for lawyers, and just say, go do whatever you want, go into family court, go into housing court, whatever. But I think having this experience requirement and requiring both a bit of education and a bit of experience, I don't think it should be, I think we should be careful about making that too onerous, I think is a very good way to making sure both that they're not in it for the money and that they have this sort of basic competence to do the job.
Thank you
And I
both.
also wanted to just add one quick thing. I think to the extent you're having a CLA requirement, looking at what I'm fortunate to not be barred in a CLE required state, but looking at, the CLE requirements that exist for lawyers, and frankly, the training as well. I mean, I don't recall in professional responsibility class ever, we covered duties regarding client funds. We never talked about how do you set up a trust fund? What are the rules for the actual management of the trust fund? And similarly, I think, that's something that's not mandated for lawyers now, but if you were going to mandate CLE, let's have it be things that are going to be sort of how to deal with the business, how to deal with the customer facing aspect of this profession.
Agreed. Good point. Thank you.
Thank you.
Really
So
appreciate it. Yeah.
we have 4 minutes left in this meeting. Are you guys ready to go with your recommendation?
Yeah, I feel like I should pay you for this session. It was very educational.
I'm wondering if, in addition to the proactive regulation piece, do you feel you want to reconsider your MCLE requirement recommendation? Not only because of what we heard today, but you'll recall at the meeting in January, there was some, there was questions about what was actually required of legal specialists, and we did get that information subsequently. So I'm just wondering if both of those might be, proactive regulation recommendation and the ongoing MCLE requirement, if you might want to revisit or visit and revisit both of those.
I think so. And the issue is sort of where are we on our recommendation? Is it 36 hours or is it 42 hours? I think those were the 2 points. I think we originally said 36 with the understanding that was the legal specialization requirement for lawyers. And I think we confirmed that it's actually 42. But I think this discussion also suggests, should some of the required CLE be not just in practice areas, but also in practice management or other areas where we think we could head off some risk and provide some useful training. I'm all in favor of that. I think the concern is we have been getting a lot of pushback on some of the things that you have raised as well, which is why do it for paraprofessionals if we're not doing it for lawyers? And we have to justify, so we basically we're trying to tack what we're recommending to what lawyers are required to do. And so as we change it, I think we're going to have to explain ourselves. But it sounds like this is going to be the most effective proactive regulation, if you will, is, we can anticipate these are difficult issues and new issues and people that don't have experience in these areas and where a lot of complaints are likely to be. So why not have some required CLE in those areas? I don't think that needs to add to our CLE total hours. I think it just needs to be another carve out of, specified hours.
I agree. I think the practical aspects of the education is really important, like practice management, trauma-informed service delivery, which we've talked about before. I think that it, as Amos said, shouldn't add to the number of units they have to take, but it definitely, we should talk about sort of structuring it in a way where we have a needed number of units in that category. I don't think we have another meeting of this committee between now and the 26th, do we? Am I wrong?
No, and so you are slated to bring your recommendations forward on the 26th, however. So if we are going to do that, we need to schedule another meeting next week and slog through it.
Yes.
If we schedule another meeting next week, there's no way to have that be publicly, unless it's,
How many days you
think?
think?
Notice. 10 days notice.
1, 2, 3, 4. Oh. How about the 22nd? That's the.
Maybe we can do this in the drafting of the report. I mean, it sounds like we're on the same page, and the question is identifying how many hours for what, really what the breakdown is that we're going to recommend, both in terms of 36 versus 42 hours, and if there's beyond what's required for attorneys, what is the breakdown that we're going to be recommending? And I don't know that I don't know what information we need to be able to be ready to make that recommendation for the 26th.
So let me just ask this, Linda, does the 22nd satisfy the 10 days? If it does, what I'm going to recommend is we do notice something, but then in the interim, we work on a draft. Yes. So that, if we don't need the meeting, we can cancel it. But if we do, we've got a draft. Okay, so if you can, we can pick a time for the 22nd, or we could do that after this via email. And then Amos and Fariba, are you still want to go with the 36, not the 42? You're just talking, or you're.
We haven't decided it completely.
so-
I mean,
Okay.
probably more. It just needs to make sense to me. I need to be able to rationalize and explain and not just pull a number.
Out of a hat.
36.
Yeah, I was comfortable with the 36, but I think the confusion is if we're tying it to the legal specialization, that's our rationale. It shouldn't be based on a mistake of what that requirement is. So, interested in your guys' thoughts, but I think that's still an open issue.
If we could do it in the afternoon on the 22nd, perfect. If not, the same time frame, lunchtime.
Amos and Leah, do you know your availability?
I'm open on the 22nd.
Yeah, the only time I'm not available is 2 to 3:30. So I could do another time.
Should we say noon then?
Is 1:30 to 3 at all a possibility?
I can't. 2 to 3:30. I really,
Oh, 2 to 3:30, you said, or
Yeah.
3:30 to 5 too late?
I can do it.
Okay. All right, I will send that out and notice it.
Thank you so much.
Okay, and one quick last question before because I'm going to write something up for you all to consider. The basic outline of the proactive regulatory recommendations that I sent out, are you okay with us starting there in this memo that I'm going to draft for you guys to review? Sort of targeted MCLE self-assessment and a more detailed like complaint architecture to get better data.
Yeah, as a starting point for sure.
Okay.
All right, thank you.
Thank you.
Thank
Thank you,
you.
Jason. Thank you,
Jason
Tom.
and Tom, thank you so much for
Thank
joining.
you.
Thank you, Linda. Thank you, Greg. Bye.